Daniel Buala, a legal practitioner and member of Lincoln's Inn, is still with us on Sunrise Daily. The concluding sentence of my colleague there, Amaka Okafor, she said that, you know, the judiciary still needs to do a lot to regain the confidence of Nigerians and, you know, get that pride of place back.
Right.
It would seem that that should be the heart of the reforms within the judiciary.
Right.
But do you think that that's what's driving this particular process?
Yes, I believe it. But first of all, let me express this sentiment. Our judges are one of the finest in the world. Our judiciary, over the years, have done their part in nursing democracy in the country. The isolated case of corruption cannot be a ground to turn the entire judiciary as black. However, when you look at events from 2009, 1999, since the advent of democracy, you look at judgments of court. And then you look at 2015, the way and manner in which cases were handled in such a way that even a 200-level student of the university starts to wonder when a court of coordinate jurisdiction sits as though it is sitting on appeal over a decision by another court of coordinate jurisdiction, it raises a question. In America, if a judgment is delivered, even though largely you have the jury handing out the judgment, and that judgment raises question, then that judgment will become subject of investigation. We have had in the country where decisions of court, whether the tribunals or the Court of Appeal, and in some cases, even the Supreme Court, raised more question than the answer it provided. And when that question began to be generated in the minds of people, that is when the law enforcement agent sprung into action. And then we are seeing this development. I still believe that the people arrested are innocent. Are innocent until proven guilty, and the onus of the proof lies on the prosecution. However, to support what the DSS did, you see this conversation at the judiciary level and the NBA level. But my opinion, the NBA first needs to reform itself. For every case in which an alleged corruption is tied to a judge, there is the involvement of a lawyer. Some of these clients and politicians that we talk about rarely have access to the judges. In isolated cases, you find that kind of situation. But it is the lawyers who have access to the judges. So I believe that the reform should start with the bar. And the bar also needs to look at some of the issues.
Wasn't that what they were talking about? I mean, starting reforms from the bar. I would think that the conversation of the NBA was along those lines.
That issue was discussed, but if you recall what he just said, the president of the NBA, he decried the fact that we have limited number of lawyers in the National Judicial Council. In other words, the NBA is calling for increased involvement in the NJC.
Do you think it should be there in the first instance? Because we've heard the NJC also saying that they didn't even think the lawyers should be members of the National Judicial Council.
As you know, as a body, whatever the president says reflects the resolution of the body. But as a private citizen exercising right of opinion, I hold a different view. I believe that the lawyers should be less active in the judiciary. I also believe when it relates to discipline, the judges should be less. What we need in the country, we need a bureau or a commission or an office that can be called in whatever nomenclature, but it should handle the investigation and discipline of judges. The body should consist of a retired Chief Justice of Nigeria or Justice of the Supreme Court retired, and the members should be legal practitioners of not less than 10 years post-call from all the law enforcement agents in the country. So a lawyer from the police, a lawyer from the Department of State Services, a lawyer from the Army, all the law enforcement agents, if we have them. When a case involving corruption in relation to a judge comes before them, you are better able to handle it because there is likely to be less interference or influence. But as we have today, NBA is 6 in the National Judicial Council, and they play an active role. Okay, look at the revised guidelines for the recruitment of judicial officers. The 2014 revised guideline now provides in Rule 3 and Sub-Rule 1B that the legal practitioner who has never at any time in his life participated in judiciary activities, whether a magistrate or a judge, can be appointed to the Chief Justice of Nigeria. That proposal, I hold the view it is uncalled for. And the reason is this. When you allow this kind of window to come in, we are likely going to give the executive in this case, whether the governor or the president, unnecessary powers to appoint a legal practitioner that may have represented the governor or the president right to the post of the Chief Justice of Nigeria. So this is a reform we don't need. Okay.
Let's quickly go to Lagos now to take some questions.
You know, Mr. Boala, quite an interesting moment it is for us. You've always highlighted the need for us to talk about, for us to rejig and better strengthen the system. That's even before the DSS moved in. But quite frankly, looking at what is happening in the judiciary, for so many, they're also asking how best to go about this, noting that what we've seen from the NJC is not new after all. There's always been that rule, that guideline for judges and judicial officers. So what else is missing in the midst of all of that?
Well, and that is why, well, what I feel or I think is missing is the transparency in the process of the recruitment of persons to the post of judges, or the promotion of judges to the Court of Appeal, to the appellate courts, whether Court of Appeal or Supreme Court. We need to know whether there is a transparent process that regulates the procedure for recruitment as well as promotion. Some people hold the view that when a judge is about to be promoted to the post of a judge of the justice of the Court of Appeal or Supreme Court, you should throw it open and it should generate a conversation where the CV of that individual at par together with the CV of a private legal practitioner that we consider is credible enough to be in that office should be checked. I don't know the details, and I'm not in a position to agree to whether we shall do it or not, but I know that somehow there is something wrong with the recruitment of judges in the country. That process, a lot of people have complained it is not transparent. Then when it comes to the issue of remuneration, I hold the view that the judges, we need to provide a very good remuneration, a working condition for the judge. For example, whether it is in America or in England, they have an independent fiscal policy that they use, and then the judges are better motivated, so that the judge cannot find as a ground whatever it is to tie up to corruption. So the judges are not motivated. And then lastly, judgments of court. We have not been able over the years to question, let's say for example, if a judgment is delivered and that judgment is considered as controversial, the NJC, do they actually investigate the judgment, or do they wait until there is a petition to the NJC about the judgment before they investigate? We need to have a framework where once a judgment is delivered and there is a conversation as to the propriety or otherwise of that judgment, there should be investigation. And it boils down to the point I'm saying that the same judges who sit over promotion and recruitment and discipline of the judges cannot play this dual role. There should be administrative body. You recruit, you promote. Lawyers, the MBA, can have an increased role there. But when it comes to the discipline of judges, we need to have an independent body that will handle it.
Tell us exactly what you don't like about the recruitment.
Well, just like in all, whether civil service or recruitment policies in the country, where we have the issue, what people call the godfatherism, you find that, if you look at it yourself, that some of the people, like a judge or a justice of the appellate court, is more likely to have a son, if he's interested in becoming a judge, become a judge, whether or not the son is passionate about the job, or whether it is skillful about the job, or whether he's even competent at all. So we need a transparent process that will check that one. I do not like a situation where what we have in the country is like a cliquish thing. Even in the case of lawyers, you find a senior advocate of Nigeria is more likely to have his son become a senior advocate of Nigeria over and above very skillful, talented, and hardworking legal practitioners in the country. So that aspect of the bar also needs a transparent process where somebody who is hardworking and is skillful, when he's appointed as a senior advocate, it should be a situation where all of us will say hallelujah, because it is done in a way and manner that nobody can question it. So there is somewhere there is a problem with respect to recruitment of either the judges or conferment of privileges to the legal practitioners.
You know, if you talk about that, which is very, very also important here, and some definitely will readily, you know, point fingers and say A, B, C is really not really right when it comes to recruitment and even promotion of some of these ones. Now, going forward, you spoke about remuneration, which you say should also help us not to, with ease, get to infiltrate some of these learned people, for instance, the judges. What else do you think we can do? Because we've seen some states, for instance, in Lagos State, we recall in the last administration what they've done in the judiciary. So many other states picked up on that and tried as much as possible to see what they could do to better take care of those judges. What haven't we done on the federal scale that you think is lacking?
Well, I think that we need to look at and that then borders on budgetary allocation for the judiciary. We need to look at whether or not the judiciary has enough money to use, and then whether or not the judiciary should independently finance their activities and not having to wait for the executive to be the one appointing or approving or disbursing money for the judiciary. Importantly also,